attention is all too often drawn to the rather high-profile campaigns for reforms of the law and human rights campaigns. And these, I find, invariably draw our attention to NGOs and to activists, again leaving the migrant domestic worker out. Now, in this centre, you have a working paper by Michelle Ford and Nicola Piper from 2006. And they explain in their paper how this failure to look at the migrant worker herself is largely because migrant domestic workers are portrayed as having little or no agency in the world economy. Now, their corrective looks at collective activism. So again, the individual has been somewhat overlooked. The subject is also neglected because the literature on socio-economic rights is very court-centric. So the main concern there seems to be social transformation through court decisions that increase the provision of socio-economic goods, often things like education and healthcare, and often through constitutional or constitutional type court decisions. So there's work by Gowrie and Brinks, and I put that, I listed that on the handout, which does allocate to the individual litigant an entire stage. So the first stage in the life cycle of public policy litigation, which they call legal mobilization, they say couldn't occur without the individual litigant playing a part. But there is no mistaking the fact that the focus of most of the essays in that collection is very, very much on court. But in fact, Gowrie and Brinks do draw out a map out relationships in socioeconomic rights. And their map consists of a triangle with the state at the top and the provider and the recipient at the bottom two corners of the triangle. And the three parts of the triangle then linked in relationship to the sides of the triangle. Now, using this triangle, they are very keen to highlight the sphere of private obligation that connects the providers and the recipients of socioeconomic goods. And they explain how that relationship, that private relationship, is all too often neglected in analysis because of what they identify as the difficult-to-shake background notion that social and economic rights must involve the state. But of course it does involve the state, but the state has somehow devolved it to the relationship between the other two points of the triangle. So with some adaptation, I think I can use this triangle, and it is in fact helpful in thinking about migrant domestic workers as litigants in Hong Kong. Migrant domestic workers with claims against their employers are essentially seeking labour rights, which in turn can be regarded as socioeconomic rights. Now, those rights might derive most immediately from private obligations, insofar as they're embodied in the employment contract between employer and employee. But the migrant domestic workers contract is in fact appropriately seen as part of the late 20th century technique of providing rights, but leaving it to the individual to enforce those rights by suing for non-compliance. Now, this is certainly the technique used in the United Kingdom for rights to equality and diversity in employment. Now, fitting the MDW contract into the socio-economic literature also makes it clear that it is quite exceptional that non-citizens, such as migrant domestic workers in Hong Kong, can access the courts for their socio-economic rights. And that's probably because the socio-economic literature has seen its main axis, again, as the state and the citizen relationship. So there is a lot to be said for looking at this the employment contract, more in the private sphere of obligations. But there are some adaptations that need to be made, or some caveats registered, because Gowrie and Brinks, for them, the paradigmatic relationship, the paradigmatic petition, is a policy-oriented petition. And here is where my work it comes with a difference. Because I'm not looking at migrant domestic workers who are suing their employers to seek policy changes that will affect migrant domestic workers as a class. They're not seeking novel extensions of existing rights, and they're not seeking new socioeconomic rights through judicial interpretation or judicial activism. In all the cases that I've studied through interviewing women domestic workers, they are really looking for corrective justice. So they already have these rights, and they're simply wanting to have them recognized, and they want the breaches thereof compensated. And wages would be a typical example of this. So a court, in responding to these petitions, can only order a shortfall in wages to be paid to the employee, but it can't dictate a higher wage than the one that was contractually promised, or the minimum allowable wage in the case of the Hong Kong domestic workers. So as a subject of study then, migrant domestic workers as litigants do deserve our attention. They have socioeconomic rights in Hong Kong and may yet win more through campaigns. But one notes, however, that the campaigns for policy changes have by and large not been terribly successful. And so if no more success is going to be charted in the future, then the enforcement of what they already possess can only become more important. And additionally, if they should win extensions to their rights, the question of enforcement is still going to be there, because litigation will remain the important means of realizing those rights. So, I would now like to outline very, very quickly what I see as the legal and immigration constraints that are peculiar to migrant domestic workers. And if you've lived here for a long time, I think some of these things will be very familiar to you. But first of all, and these are constraints that that structure a migrant domestic workers agency. So first of all, there is the fact that the migrant domestic workers has usually incurred large debts even before arriving. And we might think of these as sort of migration costs. These will normally dictate or suggest that a migrant worker stays put or remains in a situation, in an employment that she may not be entirely happy with, but it works to keep her there rather than to encourage her to leave. Second, similarly militating against bringing a claim or ending her employment is the 2-week rule, which I'm sure you're very familiar with. The third constraint is that effectively it's a choice between being homeless or continuing in employment. So if you bring a claim, it's very likely that this will terminate your employment. The fourth constraint is that assuming she's no longer in employment, when she brings a claim, she will be given a visa, an extension of her visa, allowing her to remain, but one which bans her from working. So again, that doesn't exactly encourage one to leave one's employment. So, turning now to the interviews and the data that I'm using for this research. In late 2010, the early part of 2011, 18 Indonesian migrant domestic workers who were then living in one of the shelters here in Hong Kong were interviewed. I also interviewed Filipina domestic workers in similar circumstances, but I, at the moment, have not taken that data into consideration. So almost all the migrant domestic workers who spend more than a few days living in a shelter are those whose lives have become entangled in either a civil case or criminal proceedings. In the case of all the women who were interviewed, they were in fact litigants or prospective litigants. And all these women also had a contractual claim or or they had one that they were thinking of bringing. In the majority of the cases, the women were claiming for pay in lieu of the required 1 month's notice of termination of their contracts, and also for unpaid wages between termination and their last wage packet, as well as for the cost of an air ticket and travel expenses when they come to their place of origin. Now, I refer to these collectively as N rights, and I contrast them with term rights, which is a term that I use to denote the common elements which occurred in the course of employment, such as unpaid wages up to the time of the last monthly wage being paid, rest days, uncompensated foreign wages, unlawful wage deductions occurring during employment, etc., etc. So I draw a distinction between end rights and term rights. Migrant domestic worker claims are sometimes a combination of both types of claims, although there is the end rights ones seem to occur more frequently amongst the women I interviewed. In analysing the material gathered from the interviews, I have thought about instances where the migrant worker is the prime agent in her becoming a litigant, and then I've looked at cases where she isn't the prime agent. So prime agency would be those instances where the migrant domestic worker knows or becomes aware of a violation of her contract. She may query her entitlements with her employer, and then with some advice and assistance, she issues proceedings. So one migrant worker who can be considered to have been a prime agent, the prime agent in arriving at her claim, is a woman I'm going to refer to as S17. Now S17, on arrest day, she had a conversation with another migrant domestic worker whom she said was active in an organization. Through this conversation, she discovered that her salary was unlawful. She then confronted her employer about her terms and conditions, at the same time also recording the conversation as the fellow MDW had advised her to do. In the course of replying, her employer implied that the information on terms and conditions was something that the agent ought to have explained to her. And then she added that the full salary was only for skilled or able helpers who had 4 years of previous experience. So she says it's only for those who are pintar, she says. So S17 circumstances were that she was still in her first contract in Hong Kong and had before this contract never worked as a migrant domestic worker elsewhere. A little bit later on, she requested a day off, and then accompanied by a friend who knew the way, she went to the offices of the paralegal unit at Christian Action, and from there she went to a shelter. Now she claimed for unpaid wages, wages in lieu of rest days and public holidays, as well as wages in lieu of a month's notice of termination. She also claimed expatriation costs and salary for the days worked since her last pay packet. So hers was a combination of the term and end entitlements. Now, cases such as S17s, in which the migrant domestic worker is a prime agent, are very much in the minority. So in this sample, they are part of the minority. However, several aspects of S17's cases are worth looking into in some detail, because they are in fact recurring aspects of the everyday experiences of other migrant domestic worker litigants. So first, there is the possibility of the stumbling block presented by the employment agency, who I may refer to as the EA. Now, when S17 went to the agency to retrieve her passport and contract, they refused and only produced the documents when she threatened to call the police. As we shall see, the employment agency, its proprietor and staff emerge as a key determinant in whether the MDW becomes a litigant. Second, S17 invoked the threat of the police. Now, the police feature regularly in the women's experiences. An MDW who terminates her employment is invariably advised to return to her employer to collect her belongings only when accompanied by a policeman. This advice is given so that the employer does not refuse the MDW her request, and also it reduces the likelihood that they will accuse her of theft at the moment of collecting her things. Third, S17's knowledge of her rights and subsequent action were probably delayed because she had been denied proper rest days. And she'd been denied proper rest days until she'd worked for several months, which is very common in Hong Kong. She spoke of how it was only when she had a rest day she was able to go to the Tin Hau area. And there she had it was there that she had this critical encounter with the MDW, on whose advice she later relied. So rest days obviously create the opportunities for extended conversations with other, more experienced MDWs. It's the opportunity to pick up or be given a copy of a local newspaper with all the relevant phone numbers, etc. It's an opportunity to seek advice before deciding what to do. That's not to say that MDWs who don't get rest days don't have the opportunity for acting in ways that it might eventually lead them down the route of litigation. It's simply a question of snatching moments from their daily routine in order to get away or have critical conversations with others. Now, fourth then, in S17's claim, is the fact that she had signed receipts acknowledging full salary and the rest days. Now, S17 insisted that when she signed these receipts, she was merely told that they were sample documents and not anything of any real legal significance. Such signed documents can obviously make it very difficult, can defeat a claim against an employer, which is why the strategies of recorded conversations to counter that evidence is very important. And lastly, whilst S17's own agency is clear, so too is the capacity of friends and their agency in advising her on her rights as a domestic worker. Now, S17's case is fairly straightforward in the sense that once she was clear that her employer was acting unlawfully, she took action to escape that situation. Her own resolve, combined with the conversation with the MDW she met, and strengthened by the advice she received from the Paralegal Advice Centre, led her to become a litigant. Other respondents waited a while before taking action. So S11, another migrant domestic worker, explained that she first knew her salary was an underpayment in her fourth month of work. She had, in fact, in her possession the telephone number of Christian Action, because she had been given a copy of this newspaper at the school gates when she picked up her employer's child one day, and she was given it by another MDW. But she said she didn't dare take action because her salary was still subject to deduction. So she said, tidak berani because masih potongan was what she said. And the deductions were to the tune of $2,000 in a month. So in her 7th month of work, she did go to Christian Action, and they advised her accordingly. And she confronted her employer. Her employer then threatened to return her to the employment agency, did in fact take her, but S11 en route thwarted that intention by running away with just her mobile phone number and the clothes on her back. But of course she'd already been to Christian Action, she knew where to go to, she knew about shelters. So in her case, her decision to wait until she'd been repaid her loans is probably, and I would say this is not uncommon. By leaving only after her loans had been repaid, she had, whatever other uncertainties she may face, the comfort of knowing that she had no outstanding loans. And before leaving S17, there are 2 other aspects of her experience that we should note briefly. One is that she managed to thwart her employer's plan to return her to the employment agency. And secondly, and in common with S17, her contract was terminated by her employer before she had a chance to leave. So in effect, her complaint to the employer led to her employer dismissing her. Now on timing, some of the other women who were interviewed said that they would wait until they were very near the end of their first contracts. And they also said that this would be advice they would give others. And I think this is understandable. The longer you leave it, yes, the longer the greater the amount of unpaid wages, but at the same time, the greater the amount of wages you have, in fact, collected from your employer. So in the examples I've discussed, the MDW has knowledge that she was being denied her contractual entitlements. She then either leaves her employer or her employer terminates her employment. However, the majority of the women who were interviewed only became litigants as a result of suffering physical harm in the employer's household. The harm often led to contact with the police and a shelter, and only as a consequence of these contacts did the question of suing her employer arise. So in other words, the breaches of contract for unpaid wages, etc., were not the reason her employment comes to an end. But before looking at some of the cases triggered by physical harm, I want to look at two categories which are on the face of it not very revealing, but in fact quite revealing of when people do manage to sue and when they don't manage to sue. And the first category are the end-only claims, so where somebody is only looking for their end-of-contract rights. Now this is a peculiar category of migrant domestic workers because by definition she will have had no reason to think of bringing a claim against her employer until after her employment has been terminated. Her claim is generated by the termination itself and the circumstances surrounding that termination. Thus, if you're running away, you won't have had a chance to ask or negotiate with your employer for your termination benefits. And if you're dismissed, you may have been refused those benefits point blank and have no choice but to leave immediately. So, and indeed in some cases, the manner of the dismissal has in fact been very, very distressing in circumstances where you would not expect anyone to be able to at that moment pipe up about their end rights. But these cases, and I'm not going to go into them, I argue that far from being of limited value, the end rights only claims offer significant insights precisely because in most of these end rights only claims, the migrant domestic worker flees or is evicted. And paradoxically, because she has run away or been evicted very suddenly, she has a better chance of arriving at a shelter or a paralegal advice centre. So it's the very acuteness of their situation that appears to be the most critical factor in whether they become litigants or not. But in this case, in turning them into litigants. So these circumstances of the end rights only claims suggest that those who have term claims but who are not dismissed suddenly or who do not run away from their employers are less likely to become litigants. And indeed, the majority of the women interviewed had only end rights claims, had only end rights that they were claiming. And this overrepresentation of end rights only claims in the face of widespread underpayment of wages and other common breaches of the law suggests that migrant domestic workers with term claims not aggravated by sudden departure are significantly less likely to sue their employers. Turning then to the cases of physical harm as a trigger for flight. Many of the cases, and there is a range of physical harm that appears in the stories of the women I interview, ranging from rape and sexual assault at one end to starvation, prolonged starve deprivation of food or rest, to harm caused by the employer's dog or dogs, as well as emotional abuse over a long period of time. And there seems to be a pattern of claims being brought because the physical harm has triggered her flight from her employer. And I will just tell you a little bit about one very harrowing case, and that is of S10. Now, she says that she was starved of food and she suffered mental abuse. There was almost nothing right from the beginning. There was nothing that she could get right where her employer was concerned. She described herself as having been treated worse than an animal, not being given proper meals or money in lieu, nor was she given permission to leave the house regularly for her meals. She described how she fell ill one day and she was told to see a doctor but not given any money for her medical expenses. She also complained about the fact that she had only a small supply of clothing and yet her employer didn't allow her to do her laundry until it was her rest day. She felt very bleak about her circumstances and she prepared to jump out of the window by standing on a chair. But as she did this, her purse fell out of her pocket, and scattering photographs of her children on the floor. She then explained that she was a widow, she had 2 sons and a daughter, and in fact the daughter had been born after the death of her husband, and she had to fight with family advice, etc., to keep her daughter and not give her up for adoption. And in the interview she recalls a great sadness at the moment when she saw their images, etc., etc., and thereafter told herself to try to be patient and persevere. She explained that she'd been given a fake high school diploma by her agent. In fact, she had fewer years education than the fake diploma suggested. But she was very, very concerned that she'd lost something like 5 kilograms of weight in 2 months. So that rather dramatic event caused her to pause, but she resolved to run away and did in fact run away on her next rest day. She went to Causeway Bay and there she talked to some, in fact she didn't approach them, it was other MDWs who, seeing her looking confused, inquired about her circumstances, and eventually she went to the Indonesian Migrant Workers Union and from there to a shelter, from the shelter to Christian Action. She said that when she ran away she had no idea where she should go, let alone any plan to pursue a claim. She was merely fleeing a situation where she felt that she was suffering mental abuse, hunger, and a great deal of tiredness. The frequency of cases where the litigant has suffered some physical harm, again, like the previous category I looked at, suggests that that breach of contract claims involving term rights are, again, underrepresented amongst litigants. And now I want to sort of quickly run through some other triggers or vectors, helpful as well as unhelpful, in the journey from employment to labour or litigation where migrant domestic workers are concerned. So, other migrant domestic workers as vectors, this has already cropped up in 1 or 2 of the cases I've mentioned. Individual migrant domestic workers do assist fellow migrant domestic workers. They advise them on strategy. They are there if a migrant worker asks them, makes inquiries of what is right and what is wrong in her employment situation. They can direct other MDWs to shelters or paralegal advice centres. They can give very practical advice about how to retrieve their belongings. They might accompany an MDW to retrieve her belongings. They might, in other ways, empower the MDW concerned to take the decision that she needs to take in order to leave her employer. So in all these ways, there seems to be MDWs who who intervene as a preliminary source of legal advice before the MDW is able to reach paralegal advice centres. As I've already mentioned earlier, they're also very good at passing around the free newspapers, which publicise stories of migrant domestic workers in distress who've been helped, but also the phone numbers to call shelters, advice centres, etc. And the help, as I said earlier also, rest days are obviously very important, but even where a migrant worker does not get the adequate number of rest days or no rest days at all, it's very rare that a migrant domestic worker, thankfully it's still very rare, that a migrant domestic worker is simply not allowed to leave the home. Very important in her journey to becoming a litigation are the shelters and paralegal advice centres. And I don't really have to say very much more about them, except to note the obvious, that is, in Hong Kong, you can stay at a shelter for free. Some of them ask for a donation out of your compensation if you're successful in winning compensation. The paralegal advice centres are also extremely important because they offer help, practical help, but they also act as petition writers, so they issue letters, they write letters that are to be handed to the employer, to the police, the Labour Department, Immigration Department, etc. And of course, it is through the paralegal advice centres that a migrant domestic worker's story of how she's been treated becomes translated into the language of the law and the language of a petition. But more important than that, it's where she sits down and they ask her relevant questions about her term rights, where in circumstances where she may not have thought of those at all, because what's on her mind is the fact that she's left her belongings, she's left her employer, she's not without an employer, usually from some quite dramatic event that has triggered flight or eviction. Employment agencies then, well, it's not in the business model of an employment agency to say to migrant domestic workers in distress, I think you've got a good claim against your employer. It is, however, in their business profile to recycle, if you like, labour into another contract. So there's nothing to suggest that they will direct a migrant domestic worker towards the police or towards a paralegal advice centres. And in fact, employment agencies seem to need to collude with an employer for many of the breaches that can sound in litigation. But the relationship between the employment agency and the MDW is one of some complexity, and I would like to see more of this done in the literature, but there isn't so much to go on. But we do know that migrant domestic workers are tied to employment agencies by bonds which are financial, involving loans repayable to the employment agency or to a subsidiary. And there are also other bonds of dependency and trust which may arise from the fact that the employment agency is their first port of call in Hong Kong. They may stay there for a few days, a few weeks, as newly arrived migrant domestic workers. So it may be, and it's also the case that some employment agencies have got staff who speak Indonesian, in the case of what I'm talking about here, who will act as sort of liaison people between the agency, the employer, and the employee, checking up on her in the initial days and weeks that she's all right. The early period at the employment agency is also where migrant domestic workers meet other newly arrived domestic workers, and their experiences with those other migrant domestic workers may in fact shape their expectations in respect of what is an adequate salary, what is the right salary level, what is the right number of rest days, etc. So S17, the case I mentioned right at the beginning, she said that she knew when she arrived that she was expecting a salary of 2,000 Hong Kong and that was what everybody else in that agency waiting to be placed was expecting. She also said that the employment agency had said very little about rest days and salary and told her that was something she had to speak to her employer about. Amongst the women who were interviewed, what appeared to be the case is that sometimes a migrant domestic worker, for reasons in her experience of the agency, decides that she doesn't want to go back to the employment agency. She may know that eventually she will have to seek employment through another agency, but she doesn't want to go back to the one that she came from which she came. And so she manages to escape from being sent back to the agency. On other occasions, it may be that she goes back to the employment agency, but whilst there, something occurs which indicates to her that she might be better off seeking paralegal advice. Or she's at the employment agency and about to start with a new employer when something occurs, something quite surprising occurs to rupture the relationship between her and the employment agency, and she's suddenly left homeless. And if she then goes to a shelter like Day Follows Night, or is it Night Follows Day, she goes from the shelter to the paralegal advice centre. So it's quite a complicated set of it's a complicated relationship, and it takes many forms in accordance with the migrant worker herself. A reasonable guess, I would say, is that first-time migrant domestic workers are more dependent on their agents than ones who are repeat employees. So in amongst the sample of women I interviewed, there was one who had been placed in her fifth. She was on her fifth contract. She'd gone back to the same agent time and time again, and they had found her a new employer each time. And it was only because something had happened in the course of that fifth employment that she was returned to the agent, but the agent then sent her to stay in another part of Hong Kong and left her to her own devices. And there she decided that she wasn't being looked after properly by the agent, and she took action to break the relationship with the agent. The relationship with the employer, between the employer and the employment agency, is also complex and to my mind quite interesting. If you think of a white-collar worker, for instance, your relationship with your employment agency, the hiring agency, and the headhunter, is a very short one. It's all done when you've got your employment, that's it. Similarly, the employer's relationship may be quite a short one, at least vis-a-vis that particular employee. But with migrant domestic workers and employers of migrant domestic workers, there is this tendency for that relationship to be ongoing, so that the employer thinks that when they're dissatisfied with the employee, they can send the employee back to the agent. So this idea that you can return what you have purchased from the employment agency is very, very strong. And I haven't quite got to the bottom of how the business relationship works, whether if you return before a certain date, perhaps you can get a discount on the next on the fees for the next employee you take from the agency. Perhaps things like that go on to, again, structure the behaviour of employers. So the suspicion then, I'm nearly at the end, but my suspicion is that there are many migrant domestic workers who do not litigate when they have not received their contractual rights. And this is a suspicion that you can see just from the estimates of the contract breaches that occur and the numbers go to court. But they simply go from one employer to another employer so long as nothing too dramatic occurs in any one employment, and so long as nothing ruptures their relationship with either the employment agency through which they've received more than one employment or successive employment agencies. I'm now in a position to draw some conclusions. And they are as follows, that despite the multiple structural disadvantages, as I said, many of them created by law itself, migrant domestic workers do manage to sue their employers for breaches of their employment contract. In order of their importance as causal factors, I would say that they manage to litigate because in Hong Kong you have paralegal advice centres with a depth of experience. It's also because you have shelters that do not charge a fee to the women. Thereafter, they manage to litigate because of the developing capacity of MDWs to advise and assist one another. This, of course, is in turn to do with the political and social space which has allowed, in Hong Kong, which has allowed NGOs attentive to migrant workers to operate, to spread their message, and to help with that capacity building. MDWs as sources of advice are much needed, given that the number of MDWs reported, reported that they had been given advice, but also because they are much closer. They would be much closer to a physically speaking, geographically speaking, and in time as well, closer to any MDW who may be in distress. MDWs often said in their interviews that the advice that they got from other MDWs after they'd arrived and when they were in distress contrasted greatly with the advice that they'd been given before they left Indonesia. So the advice that they were given before leaving Indonesia was more advice and advice about sexual relationships. Now, after MDWs then, there is the role of the free newspapers that circulate against MDWs. And these appear to be much more effective than the guidebooks, nicely printed and collected by the various authorities and prepared for MDWs, because these tend to be confiscated when the women arrive at the employment agency, and if not confiscated then probably taken away by their employer. One migrant domestic worker did say to me that she had kept her guidebook and she had read it as frequently as every night, she said. It didn't stop her from being very confused after she left her employer, but she described how her employer asked her what she was reading and was very curious about it, but she managed to say, oh well, it's nothing, don't worry about it. Also, very few women said that the Indonesian consulate had been critical in their journey from being an employee to being a litigant. Next down, I would say that migrant workers do count on the police, and they are a very important factor, an important player in their journey from being an employer to being a litigant. Though amongst the women interviewed, some of them did say that the police told them to go back to the employment agency rather than to a shelter. So perhaps it's a case of more training that is required to ensure that the police know where to direct them to. Thus far, I have not said anything about the personal capital. I've not touched on that of individual migrant domestic workers as litigants, but obviously things like their maturity, their experience, their work experience, their education, their financial situation, all of these balanced against their actual employment conditions would obviously play some role, I would say, in helping them decide what to do, or perhaps even come to the realization that there is something wrong which could result in a claim against their employer. But as my study, I hope, shows, migrant domestic workers for themselves and for others are everyday actors who can and do change the course of their own paths, and who negotiate hurdles and challenges to improve their fortunes or avoid further harm. As everyday actors, the women who were interviewed sometimes used the narrowest of opportunities they had to seek advice or to collect vital evidence with which to overcome earlier acts detrimental to their success of, their chances of success, like signing receipts for full wages and rest days. An MDW might voice her complaint to her employer. She might, with the help of other MDWs, calculate when best to run away from her employer. She might have to resist being sent back to the employment agency. She might have to engineer her escape from the employment agency. We also see how some MDWs are not merely reactive, but make deliberate use of litigation to further their own interests. So although not in the sample of women I interviewed, but anecdotally we do know that some MDWs initiate litigation which they later withdraw to buy themselves time, and that's because of the 2-week rule, because otherwise they would have to leave and the cost of returning to Hong Kong would be very high. So initiating or reacting, they weigh in the balance the options they have at key moments to find their way to ultimately to the tribunal. As a matter of policy then, the continued funding of paralegal advice centres, shelters, proper training of the police, ensuring that those free newspapers continue to circulate, all these things appear to be absolutely vital. But so too is the commitment of the legal system of Hong Kong to allow employment disputes of MDWs to continue as normal disputes rather than being ghettoized into some special dispute resolution channels, special but not specialized often, as we have in a number of Asian countries. So as things stand, litigation is still one important channel through which corrective justice may be obtained by high courts to Hong Kong.